That compensation in your hands, Mr. Trust. You're holding that in trust for Sunshine, because it doesn't matter that you owned or you had the shares in Sunshine at the time. Sunshine is a separate legal vehicle, and the compensation should be paid to Sunshine. Alternatively, even if the compensation isn't paid to Sunshine, you can't get the compensation for the shares for which we borrowed money to buy and leave us with the liability to pay back the investment loans. So at the very least, we want you to pay back to Sunshine what was borrowed from SSB so that Sunshine can in turn pay.
Their case has been instituted, and today the Caribbean Court of Justice ruled that Sunshine Holdings deserves to be heard.
It is the view of this court that whatever merit there may be to the substance of this application, and we expressly do not decide whether there is or there is not any such merit, we are unable to entertain the application. The tumbling order cannot be used as a basis for proceedings to be instituted or relief to be obtained by or against an entity that is not a party to the settlement agreement. Nor should the tumbling order be invoked when all sides acknowledge that the payments ordered to be made by the Government of Belize to Boyce and the trustees of the B.T.L. Trust have in fact been made. We agree with the Government of Belize that in this suit, this court is now functus officio. The underlying premise of this application appears to be the relationship between the government and Sunshine and the extent to which, if at all, they should be treated as distinct entities. Arguments on that matter should be addressed outside the framework of the tumbling order in proceedings in which Sunshine has a voice. The application is therefore dismissed with costs to be taxed if not agreed.
Representing the government, Solicitor General Nigel Hawke found success with the argument that the court's function in the long-running Dean Boyce British Caribbean Bank Dunkeld International Investments B.T.L. Employees Trust case was over as far as they were concerned.
They filed an application to the C.C.J. seeking to have the claim filed by Sunshine dealt with at the C.C.J., saying that we have abused the process of the court. Fundamentally, what the court has done is agreed with us that the court has found us, since the issues between the government and them has basically finished. The issues are now moot, since we paid all the monies in accordance with the order of the C.C.J.
But the court, of necessity, did not consider the relative merit of the case, and that leaves an opening for the trust and senior counsel Lamont Courtney. They accused the government, as the moving hand of Sunshine, of seeking to manipulate November's result after remaining on the sidelines through the main litigation of the case dating back to 2010.
It is a very strange claim because the government has agreed by the settlement agreement of 2015 to pay the compensation to the trust. It has now paid it to the trust and now it is seeking to get it back. What is strange is that the government also wants to keep the shares that the trust had owned. So we applied to the C.C.J. to ask the C.C.J. to order the government to stop Sunshine from pursuing that claim in the Supreme Court. And the court made very clear that as far as they were concerned, we should fight it in the Supreme Court rather than starting it in the C.C.J. It's all the compensation that was paid to the trust and the $20 million in the loans. It is a rather strange situation because, as you know, Sunshine all this while had not participated in anything. Has never presented a claim to the government, has never said that it was entitled to compensation. Sunshine is owned by the government. So what you have is the government suing the government, asking the government to take away trust money from the trust to pay it to the government. It is circular, and we will be submitting to Justice Abel that it is an abuse of process and that it should be struck out.
Aaron Humes reporting for News 5.